Hello friends, under Article 141, 142 and 144, the orders and the judgments of the Honorable Supreme Court of India are entirely binding in the entire country on civil and judicial authorities as well as like each and every person. Alright, but on the ground level, what happens when a counsel, that is an advocate, represents a case in any of the trial courts or high courts? What I have noticed is whatever the judgments they quote in support of their cases, normally they call it, in legal language they call it citations. Most of the judges they don't consider them, unfortunately. Some do consider, some give great respect to the judgments and orders of the Honorable Supreme Court, and I've personally seen such kind of judges getting elevated to the Honorable Supreme Court from the High Court level. So that's a very good sign. But unfortunately, some people, some other judges, they don't give much importance. So what can be done in such kind of scenario? Honestly speaking, nothing can be done. Why? Because that is the discretion of the particular sitting judge whether to consider the judgment and order of the Honorable Supreme Court, whatever citations you are providing in support of your case. The rule of law is whatever judgments we are taking, relying upon in the lower courts or in the high courts, based on that particular judgment, the question of law has to be considered by the judges and sitting judges, what I mean. And the second thing, there is nothing to do with the facts of that particular judgment which you are relying, nor your facts of your case. Even the facts there is no need for facts to match. Judgments are particularly relied upon basically on question of law, because if you want to look up to the judgments, the question of law is of utmost importance. This is what the Honorable Supreme Court has reiterated several times. When they pronounce any judgment, that will be whatever the best part out of it can be taken is the question of law. There are two parts of the judgment that is discussed in the doctrine of stare decisis. The one is ratio decidendi and other one is observations, obiter dicta, that is called, that is observations. So in other countries, whatever the other Supreme Courts in other countries say, observations doesn't matter much. But in India, fortunately, observations matter a lot. Observations is nothing but obiter dicta. Obiter dicta and ratio decidendi is nothing but reasons. Both of these things are very important. Reasoning is important as well as observation is also important. And both are binding. This is called a binding precedent. So in the entire country, they are binding precedent in the trial courts as well as the high courts. Under Article 141, 142 and 144. They specifically state that. Alright. But as I told you, unfortunately, some sitting judges, they don't consider it. Sometimes it becomes painful that the sitting judges are not considering the question of law that is being reiterated in the judgments of the Honorable Supreme Court. See, basically rule of law is, if you go through any books, the Criminal Major Acts or Civil Procedure Code, whatever statute you are talking about, there will be various sections, okay, which will contain ingredients as well as certain kind of procedure that will be contemplated in those particular sections, and moreover it will have some ingredients and the procedure as well as the content. So now what happens, based on that, no court can decide any case. The court has to rely on the interpretation what the counsel is doing, and the interpretation flows directly from the judgments of the Honorable Supreme Court or Honorable High Court, also form binding precedent to the courts below, so the trial courts. So therefore it all depends on the binding precedents on whether of the superior courts. The trial courts have to respect the High Court and Supreme Court judgments. High Court has to respect the Supreme Court's judgment. That is called judicial propriety and decorum. Alright, that is very important. See, and one more interesting fact is the Honorable, whether if it is ratio decidendi and observations, the Supreme Court does not have any binding precedent of the previous judgments. It's up to their wish. Okay, but still they give lot of respect. I haven't till date I haven't seen a single Supreme Court of India judgment which have never quoted the earlier judgments. So that is the kind of respect what they always give to the earlier judgments. Whether even today there are judgments which are almost 6 or 7 decades old, which have been pronounced in 30s, 40s. Even to that matter of fact, Privy Council's judgments are also given lot of presidential value. Okay, and even the Supreme Court time and again quotes the other country judgments also, and sometimes some royal commission or royal societies observations as well. And sometimes Honorable Supreme Court also appreciates even the trial court judgments a lot. They also form the part of observations of some crucial judgments of the Supreme Court. In that scenario, those observations, what are the findings of the trial court or the high court, those observations will also become a binding precedent, because the Honorable Supreme Court borrows them. Wherever some good is there, that will be borrowed and brought it to the ambit of the judgment. That is the beauty of the judgment of the Honorable Supreme Court. Wherever good things come, they borrow it and they bring it to their judgment. And to be honest, my dear friends, lot of advocates and counsels always have heard this from many of them stating that it's very difficult to understand the language of the Honorable Supreme Court of India's judgments. To be very honest, even I too agree with the same thing. It is not that easy. The kind of language what the judges use, I don't think so any other professional can ever use such kind of high profile language, because the legal language is formed, the formation of the legal language, though it is in English, has got lot of terminology from various other languages also. Foreign languages. So those will be quoted, and the judgments, understanding the judgments is a very tough thing, and we need to go through them again and again. Lot of experience is required to understand them, and the person and only the counsel or the advocate who knows the judgments of the Supreme Court, who has got the judgments of the Honorable Supreme Court on his fingertips, will succeed as a big time counsel. There's no doubt about it, because it's all about interpretation, as I told you, and interpretation flows from the Honorable Supreme Court. It's not in the statutes, or it's not in the any of the major acts. Everything depends on the judgments. Alright, for example, if you talk about a cheating case of 420, you have normally some kind of ingredients that are required, that is dishonest inducement, delivery of property, and wrongful gain. But these all three things will be thoroughly discussed in various judgments of the Honorable Supreme Court. Dishonest inducement, there are many judgments. Delivery of property, there are many judgments. Again, wrongful gain also, there are many judgments which thoroughly discussed. So that is where the interpretation is. So on the question of law. So therefore, based on that, the advocates who are representing their clients will have to argue in the trial courts or in the high courts. So that is what I wanted to tell you. Again, I'll come back to the thing, stare decisis. That is consisting of obiter dicta and ratio decidendi, observations and reasons. And if the honorable sitting judge is not listening to you, you can bring to their kind notice, you can file it in writing. At least when you go for an appeal, you can bring it to the notice of the higher sitting judge that the court below has erroneously taken a decision without following the binding precedents, where the judgments were quoted and even filed in written, but they haven't paid due attention to it. Therefore, you can beg for some good reliefs in the superior courts. That's all what we can do, because I hope the judiciary has to improve on this particular aspect, that is called again judicial propriety and judicial decorum, because the higher superior courts judgments and findings have to be respected. That is very important. If I work as a manager for my boss, who is a CEO sitting in some other country, if my boss refers somebody to me, I have to pay due attention to him. Otherwise, my boss will be displeased. He will not be happy with me If I straight away bluntly say, who the hell are you? You just go out and I cannot pay attention to you. I have to hear him. I have to, consider his grievance. In the same way, the sitting judges also has to consider the grievances and the judgments and orders of the honorable higher courts, the High Court or Superior Court. I'm just, it's my opinion. Anyhow, that's all, my dear friends, for today. I've told you about the articles of 141, 142 and 144 which form binding precedents. Thank you, my dear friends.